Welcome to another edition of the Trustcast Show, and I'm really pleased to have on with us Brett Tishler. Welcome to the show, Brett.
Hi, how you doing?
Okay, so let's just launch in. Brett Tishler is a Philadelphia attorney who spent nearly 2 decades flying across the country to investigate workplace disasters, crane collapses, smelting explosions, French cave-ins, and recovery money that most people don't even know insurers are owed. Last year, he and his team moved to a new firm to build what they're calling the largest dedicated workman's comp subrogation practice in the country, and we'll get into what that means. So, Brett, you spent your whole career on workman's comp subrogation, a niche most people have never heard of. My first question was going to be what pulled you into it, but explain what workman's comp subrogation is for our audience and for me too. I honestly, I don't know.
So workman's comp or workers' compensation subrogation, work comp subro. The elevator pitch I just tell people is I'm just a personal injury attorney because it's easier. But the fact, but the fact of the matter is, when you work at a job, if you get injured on the job, you get workers' comp insurance. They pay for your medical insurance. They pay for your wage loss. And the job of work comp is to get you back to work. It's to get you back
Yes.
to what they call maximum medical improvement. That's work comp. I'm not a work comp attorney. That's what that deals with that. The work comp insurance company contacts me and says, "Hey Brett, we got a guy who just got his arm ripped off in a horrible injury at work. We're going to be paying millions of dollars in benefits and wage loss. We want you to get that money back. Who is ultimately responsible?" So then they hire me, and I look at how did the accident occur? What's the machine involved? What are the facts involved? And is there an outside party that's not the employer? Because you can't sue your employer if you get work comp. The employer's immune. I can't sue the worker because we're giving him the money. We want to get it back. So who's that outside party that we can pursue? And that's what I end up doing. And a lot of times I will work with the injured worker. I'll work with their attorney, and together we'll pursue that outside target. A lot of product liability accidents, things of that nature. Another way to think about it is, Zane, I'm sure you drive a car, right?
Yeah.
Okay, you have insurance for your car. When some knucklehead rear ends you, you're thinking, shoot, I gotta call my insurance company. I'm gonna have to pay my deductible. This is ridiculous. It's not even my fault. Well, the insurance company contacts me to go after the knucklehead that rear-ended you to get back all the money spent to fix your car so you get your deductible back and your rates stay the same and you're fine. So that's what we're doing. To the extent we recover money, then the insured or the employer, their mod history, their insurance history goes back down, and they're happy. We're happy. That's we're going after the ultimate tortfeasor.
Yeah. So let's say, for example, you have some sort of an industrial accident, and you say you're not going after the employer, you're not going after the employee. You're looking at somebody else who may be responsible. Could it be like a local city who didn't do the inspections right, or would it be the manufacturer of the machine, or all of those things?
It's depends. It could be anything. It could be anything. If it's, I mean, I do any work related accident I'm involved in, and usually they're not calling me unless it's a horrible injury. I mean, in other words, I'm not getting called if it's a $2,500 claim because a guy tripped over a curb and just bumped his knee. But when a guy slips and falls down a pit and ends up becoming a quadriplegic, they're calling me. Who can we go after? Is it a general contractor? Is it a construction manager? Was a machine involved? Was another? It's endless.
So, so tell me about this. Has got to be a fairly comprehensive investigation. You guys have to be like super investigators. Talk to me about that process. So I have this list of questions. I always have this list of questions, and I go by it sort of, but then I just let my curiosity go because this is what I'm thinking people are thinking because this is really interesting to me.
So again, it depends on the facts. Every case is different. If it's a motor vehicle accident, let me see the police report. Let me look at that. But we had recently, or not recently, a couple of years ago already, but the case is still ongoing. It was a guy fell off of a platform at an Arizona power station, and we get the call. hey, this accident just happened, literally just happened. We want somebody to figure out get out there immediately because we want to make sure evidence is preserved. We want to make sure everything is documented. So we're going out to find out what happened at this power plant. We're hiring an expert to go out immediately to laser scan the whole entire area, which is really cool in and of itself. We're trying to find out what are the best experts that we need to get involved in whatever particular accident. Do we need an electrical engineer? Do we need a mechanical engineer? It's obviously fact specific. We just got a loss in the other day, for example, in Duluth, Minnesota, where a forklift was picking up a giant roll of paper that weighs like 650 pounds, and the paper fell off the forklift and crushed a guy from the waist down.
Wow.
And so what we're trying to find out is, what kind of forklift was it? Was it supposed to be lifting up this paper? Did the forklift malfunction? Did the attachment on the forklift malfunction? All things of that nature. So it's fact specific. We're working with a variety of experts, and always learning something new. That's one of the cool things. I always say, if you watched Mr. Rogers back in the day, and there was an episode about the Crayola Crown Factory, and it shows how the crowns are made. That's like my job. I've seen how the crowns are made. I've seen how the cardboard box that ships the crowns are made. It's really seeing every part of industry that you can think of.
So you have to hire a lot of people. So is it usually the insurance company that hires you at the outset?
Yeah, it's usually the insurance company. They're the ones that are issuing the benefits. They'll call us up. They'll give us the initial information. I mean, they're usually the first company that gets notice of a loss before any other attorney. Because what happens is the worker gets hurt, and the company, the boss, the employer, calls up the work comp company. Hey, we have a loss that just happened. We got to get somebody out here from the work comp carrier to deal with the medical stuff. And then as the work comp adjuster comes out and says, hey, this is going to be a big loss, we got to get subrogation involved, which is where I come in. So and we found that early intervention, meaning we get involved, hopefully, if everything's working right, we're involved within a day after the accident occurs. So we're literally able to investigate losses. Things are still in the spot where it happened. Everything's still the same, as opposed to a personal injury attorney that might get this case from the injured worker a week, a month, a year after the loss, and then trying to recreate what happened. We're already there.
So your team's collectively recovered billions of dollars for clients. What's the case that taught you most about how to win these fights?
So one of the interesting things about my practice is it is a 50-state practice, and workers' comp subrogation is statutory, as opposed to regular property subrogation, which is equitable, which is just fairness. Hey, we're suing you because you really caused the problem. We're going to go after you. Work comp is statutory, which means there are 50 different statutes, and every state does it differently. And, it's so how you recover really depends on the leverage you have. There are some states that say the worker doesn't have to repay the lien until he is made whole. What does that mean? That's virtually, how can you be made whole? The worst injuries, you're never going to be made whole. There are other states that say the workers' comp carrier gets the money first. Out of any recovery, the worker has to repay that lien. That lien gets repaid $1. We have the leverage there. So it depends on what state you're in. But one of the interesting things is the way my practice is, I'm not adverse to a plaintiff's attorney. A lot of times they think I am. I'm not. I'm on the plaintiff's attorney's side. I want to help them. And a lot of times they love working with me. I get an attorney that calls me up and says, I understand you've done an investigation. And I go, absolutely. I've had an expert out there. I've developed a theory. I've placed targets on notice. You want to work with me. I want you to make $1 billion so you can pay my lien back. And I've worked with some of the best attorneys in the country, and it's fantastic to see how some of these guys operate. I've learned a lot over the years.
So discovery with you is a completely different animal than discovery on a general personal injury lawsuit.
Well, sure. Yeah. I mean, again, it's obviously fact intensive. If I get a case where we're dealing with just a horrible motor vehicle accident, a lot of times, for example, And I joke, being from Philadelphia, I'll get a horrible motor vehicle accident and I'll say, well, there's got to be a personal injury attorney because there's an attorney involved before the accident even happened. In a case like that, I'm sending out a letter and saying, I'm the lien carrier. You got to deal with me when you settle the case because they can handle it.
Mm-hmm.
More often than not, I'm getting a product liability case. I'm getting a case involving a manufacturer, a machine, or some kind of industrial accident, and I have access that no one else does because if it happened on the employer's premises, and remember, it's the employer who has the work comp policy. It's that their insurance company is hiring us. So we're representing the employer as well as a non-party because they can't be sued because they're the employer. But I get that access, right? The employer says, here's our machine that malfunctioned. Here are all the witnesses, and it's up to me. I get that number one access that nobody else gets. So yeah, you want to be friends with me if you're the plaintiff's attorney because I want to help you.
So you litigated a 4-week trucking accident trial in North Carolina that ended with a $17 million verdict. Take me inside that courtroom so I get a kind of a feel for this.
That was an interesting case. I tried the case with one of the best North Carolina personal injury attorneys in North Carolina, and his name was Wade Bird. He's still around, and he's one of those good old Southern gentlemen. Anyone, if you go to North Carolina and say, do you know Wade Bird? Everyone knows who this guy is. And the case, what's that?
B-U-R-N?
B-Y-R-D, Wade Bird.
Wade Bird, okay.
He's like one of the best personal injury attorneys, and he's been doing it for probably 50 years at this point. And the case in and of itself, North Carolina is what's called strict contributory negligence state, which means if the plaintiff is 1% at fault, you can't recover. Zero. Contrast that with, Zane, you're in California?
I'm in Washington State.
Washington. I think Washington, I want to say it's can't recall if it's comparative or not. But California, for example, is a pure comparative negligence state, which means you could be 99% at fault and still recover. Your recovery will be reduced by 99%, but you still recover. So North Carolina is difficult. There's 5 states that are strict contrib, and North Carolina is one of them. And in this particular case, the plaintiff, there was a truck driver, and he was having problems with his tractor trailer. He couldn't get it to power up properly. He was going like 20 miles an hour. So he pulls off into a gas station, and he calls up his boss, and he says, I'm having problems with the truck. And they said, don't worry, we're going to send the house mechanic over. They were only like 10 miles away. So the house mechanic comes over. He says, hey, you know what? I know what the issue is. We're going to have to just drive back to home base, and we'll address it there. So let's get back to home base. We're going to go on the interstate because it's only 8 miles down the interstate. We're going to put our flashers on. We're going to go however fast you can go, and that's what we're going to do. And they're doing that, and it's a 2-lane road. As the experts would say, flat as a pancake, straight as an arrow, all right? Just clear day, nothing. There was this grease truck that was driving at the speed limit. There was no minimum speed, but this grease truck was driving 67 miles an hour. It was a 70 mile per hour speed limit.
Yep.
The grease truck, for whatever reason, never stopped. And rear-ended the house mechanic. He went right off the road, crashed into a tree and died, and then continued to go into the guy driving the tractor trailer and completely demolished that car. So we had 1 death and 1 guy who suffered traumatic brain injuries. Horrible accident. Rear end accident, right? Come on, let's settle the case. And the defense was like, nope, we're going to defend this case because your people shouldn't have driven on the interstate. They should have pulled off. They should have stayed they should have gotten towed. They should have done a lot of other things. And you're at least 1% at fault. And we tried the case over that. Mm-hmm. And, we had accident recreation experts who were talking about the line of sight and distance reaction times, and it was a whole thing. And there were a couple good gotcha moments in the case for just a rear accident case. And I mean, I could talk about this case for hours, but the bottom line was obviously the jury was like, no. At one point during closing, I remember saying, the plaintiff is actually, the defense is actually arguing that the plaintiffs are liable because they didn't look behind them as they were driving on a straight road. And they were like, yeah, that's right. But you're at fault. So, and my role in it is in North Carolina. So part of that strict contrib is the defense can also say that the employer was also contributorily negligent. And if the employer is found 1% at fault, then the work comp lien gets waived, completely waived. So they were arguing this in this case, hey, the employer's negligent because the vehicles weren't working. And they knew or should have known that there were problems with the vehicles, or they didn't train their employees that if you have a problem, you shouldn't drive on the road. So that's why I was involved. And I partnered up with Wade and we tried the case together. And, we ended up I got a non-suit on the defendant's arguments against the employer, meaning they were unable to show any negligence on the employer. And then obviously we won. We got a verdict for the plaintiffs in the amount of $17 million for both plaintiffs. So it was a fantastic result.
So here's it's not a strange question. So a lot of attorneys will watch this podcast too. I mean, in addition to, people who are just interested. So how do you slice up the pie in something like that? Because you have the traditional personal injury attorney, and they're getting whatever a third or whatever statutorily they're allowed in that particular state, and then you guys obviously have to get paid because you're a big deal how do you slice that up?
Sure. Well, number one, again, very state specific. So depending on the state you're in, we'll address how the lien is to be repaid. And, depending on the agreements I have with plaintiffs' counsel, a lot of times I will work with an attorney under a joint prosecution agreement where we're working together and we handle the fee through that JPA. Other times, certain states, if I file a lawsuit first, then there is nobody taking any fee from what I recover. And a lot of times, again, it's very heavy on the statute. So in that trucking case, for example, because I was involved actively representing my clients, my fee, my portion, I got my lien repaid 100%, and my fee came from there. And the plaintiff's attorney did not take any fee from my portion of the recovery. So that's how we split that.
Interesting. So last year you left White and Williams after 15 plus years, and probably people said you were crazy. What made you and Rob Kaplan decide it was your time to go? Did people say you were crazy?
Well, a lot of people said it's about time. White and Williams, it's a great firm. In fact, I just had a conference where we saw the guys there, so it's a great firm. Our practice, and it's Rob Kaplan. I call him Captain Kaplan. He has been doing this practice for over 30 years. And the two of us, I've been working with him for the past almost 15 years, doing it. I was doing property subrogation at White and Williams for a couple of years, and then I met Rob, and then we started doing the work comp subrogation. We found that we were trying to grow, and we found the firm, Derrevere Stevens, where we're at now. It's a great opportunity for us to really join them. Their culture really matches with how we are, and they're enabling us to really boots on the ground and grow really fast. We're also, the way our practice runs, we're a remote practice. I am out of the office more than I'm in the office. And at White and Williams, we had traditional office space, and I had a beautiful corner office that I was never in. And I had overhead attributed to me that wasn't necessary because I was never there.
Yeah.
So now we're a much leaner force where we are now. I'm in my house right now working remotely. I was just in Atlanta yesterday. Barely got out because of all the TSA issues, but that's another story. Yeah. But we're able to be a lot more leaner and more efficient where we are now. So that's that's the biggest reason we left.
So you and Rob are it. Is there other attorneys in the firm that you guys started?
Absolutely. So we left White and Williams. We took our department with us. It was us. It was 3 other attorneys, and now we have 3 other. So it's 5 of us. We just hired a 6th to be part of our team. He's been an attorney for 11 years doing work comp defense, so he's made the jump to plaintiff's work. We also have a couple of people from Derrevere Stevens who are based in their Florida office who do work comp subro as well. They were doing it mainly just Florida, but now that they're with us, they're branching out and doing some more states. So we've got 8 attorneys full time doing work comp subro.
Wow. So that's a pretty good start.
Yeah,
Correct?
no, it's great. It's such a niche practice because it's difficult. Remember, it's statutory. It's different.
Mm-hmm.
Every state's different, and there are so many different ways. You can't just dabble in it. You know, for the traditional way of doing work comp subro is you have a work comp defense attorney who sends out a letter that says to the plaintiff's attorney, "Hey, there's a lien, statutory lien. If you make any recovery, you have to pay us back." And that's all they do. Our practice flips that on the head and we say, look, we're investigating these things. We are actively pursuing these things. If there is no plaintiff's attorney, we're pursuing it directly, assuming the state lets us do it with the jurisdiction we're in. If there is a plaintiff's attorney, then we're helping them to make the case that much better. So we're doing a lot more than just sending out a letter. And we're seeing, you know, our clients that work with us see that the proof is in the pudding.
So do you must have competition. So how do you market yourself, or do you market yourself? Do you go straight to the insurance companies and say, "Hey, here we are, and we can help you with this," or how does that work?
It's a little bit of everything. We speak at industry conferences. We just got done a conference. It's called NASP, the National Association of Subrogation Professionals. Try to say that 5 times fast, but we just got done a conference where I'm a speaker all the time. Rob's a speaker all the time. We meet with insurance industry clients all the time. We provide presentations, word of mouth. I mean, people come to us, and it's you know, again, it's there is competition, but it's a hard practice. So either know what you're doing or you're not. And we find that a lot of other attorneys, you take it away from the defense counsel perspective, other people who try this practice, they might just stay in their own lane, in their own state, or their own little tri-state area. But nobody does it the way we do over 50 states.
Right. So here, let me do some rapid fire because it's always fun. Philly cheesesteak, Pat's, Geno's, or somewhere else?
Somewhere else. If you're going to Pat's or Geno's, you're a tourist.
I agree. I totally agree. Whiz, no, thank you. Most dangerous job site you've ever walked into?
Ooh, that's a tough one. I was at a smelting a factory in Alabama, and I think everywhere I looked, there was something that was going to explode, and that was not fun.
Do you, just as a side note, do you counsel potential insurers when you go somewhere and you see things that aren't right? Do you tell them, hey, you need to reevaluate this?
Well, absolutely. A lot of times when I'm on a site inspection with my expert, it's just us. It's not other parties.
Right.
If we see something dangerous, we absolutely say, you got to fix that. You can't do that.
Yeah.
I mean, that's just, you know, you have to. Whether they listen or not is another story. But yes, if we see something, we absolutely call attention to it.
So courtroom or settlement table, where are you most comfortable?
Either or. I love being in front of people. I hate the minutia of filing motions and all that stuff, but I love being in front of people. I would have been an actor.
Does any attorney like the minutia? I guess there are some that want to stay behind the scenes.
There are. You'll never see them because they're behind the scenes.
Best piece of advice you got from Rob Kaplan?
Patience. It's something. As I'm growing older, when I first met Rob, I was in my early 30s. And I remember going to mediations or court, and I was fired up. If somebody said, you know, the long game, forget the long game. If the case is going to settle, it'll settle. If not, let's try it. Rob has taught me just relax, breathe, wait. You have to play the game. You got to wait things out. And as I'm getting older and younger attorneys are in, I see where the spit and fire is. And it's like sometimes there's you just need to relax. You need to let the process play out.
So the one thing people get wrong about insurance lawyers.
Well, we're doing God's work. They think we're the devil. We're doing God's work. We're bringing insurance companies money. What better purpose in life could there be?
So, first thing you do when you land in a new city for a case.
First thing, I get my car.
Okay, this is rapid fire, so that's a good answer. Okay, so you recovered $1 million in a case involving a 40-year-old farm equipment that amputated a worker's arm. How do you prove a product is defective after 4 decades? That seems like a tall order.
So it's not proving that it was manufactured defective in that case. It was a design defect. And again, depending on the state you're in, that was a Pennsylvania case. Pennsylvania has no statute of repose, which is a time limitation that bars you from pursuing a lawsuit after a certain amount of time passes. So in Pennsylvania, there is no statute of repose for product liability. So this was a 40-year-old piece of machinery. And what happened was it was a potato seed cutter. So you would take a potato seed, you would cut it into pieces, and then you could plant the potato to raise your potato crops. They kept on getting a jam in the machinery. And this guy, it was a kid, he was like 19 years old at the time. He would stop the machinery, he would unplug it, he would take the guards off, which you'd have to unscrew all these things, take this guard off, and he would see where the potatoes were getting jammed, and he would unclog it, put the guard back on, screw everything back up, plug it in, do it again. This process played out several times. It took about a half hour to unscrew and take off the guard, everything. And we said, and the guard was just a piece of a big sheet of metal. You couldn't see through it. So he was unable to see what was happening. So the last time it happened, he unclogs it. He then runs it without the guard on because he's troubleshooting, because he wants to see if this thing gets clogged again, I want to see where it's coming from. And then he sees it starts to clog, and he takes a stick to try to unclog it while it's running. And there were gears, and it pulled his sleeve into the machine and cut off his hand.
Wow.
So we looked at it, we said, well, geez, that's a horrible design. You can't see if you put the guards on, you can't see how it's clogging. So what are you supposed to do? And we came up with different ideas. What if you had a guard that you could see through, whether it's plexiglass, whether it's just like a diamond cage that you could see through, or how about like a trunk, like a lid, if you were to be able to open the cage up and there was a switch, so when you open it up, the machine would automatically turn off. So that's all stuff that we looked at, and that was the theories. It was a design defect, that it was reasonable that you knew if this thing was going to get clogged, how do you unclog it? And how do you troubleshoot it? And that's the kind of things you're looking at. So really, at the end of the day, what I do with all these product liability cases, for the ones that are successful, we're trying to make products safer so we don't have to do this stuff again. It's why do you think there's a warning that says, watch out, don't do this, don't do that? And product liability in and of itself, what I always tell my clients is, if there's a hole, somebody's going to stick something into it. And I get in trouble for saying that, but it's the truth. And they automatically say, well, Johnny should have never stuck his hand in that. It's his fault. No. Why was Johnny able to stick his hand there? He shouldn't have been able to. That's product liability.
So you said something there clicked in my mind, and I thought of the warning labels on cords. Any cord, the warning label, it drives me crazy. That's the first thing I do. I buy something, I cut that bastard off of there. It just drives me crazy. Anyway, that's a side note, just a personality thing for me. So this is such an interesting topic, and we're running out of time. I could probably go on for quite a while asking you questions. So tell me, if someone wanted to get in touch with you and they thought, oh, I'm an insurance company, or I have some sort of subrogation claim, or want to know more about subrogation because I have potentially some, how would they get in touch with you? What's the best way?
They can look me up on LinkedIn. Just type in my name. You'll see me on LinkedIn. I post my travels. And they can also always give me an email at bnt@Derrevere Law, DERREVERE law.com. It's like Paul Revere, Derrevere.
Yeah.
Or you just look me up online and give me a call.
Okay, great. Brett, thanks for coming on. Hang on.